Can't tell
So ready to start yours then? I'm ready.
Ms. Abraham, can you hear me okay?
Yes, sir.
All right. I don't see any phone numbers dialed in from TDCJ. Granted, they could have given up on us.
Well, I called them and told them we were about probably 20 minutes that we were having technical difficulties.
Okay, so they know we're delayed. Okay.
Yes, sir.
All right. Who do we have up there that's available right now?
Shrav is ready with his client.
Bringing them in.
They're bringing him in right now.
All right. Is that a plea?
That's a plea. That's right.
Yes, sir.
Has he already signed the plea papers?
Yes.
Okay.
Yes, sir.
Have Mr. Simpson step on up then. And Ms. Heisel or Mr. Cox, are you there?
Yes, Your Honor.
Someone tell me what the terms of the plea are.
Yes, Your Honor. To the third-degree felony of driving while intoxicated, third or more, upon a plea of true to the state's motion to revoke, we're going to recommend 3 years confinement in TDCJ with balance of financials, which includes $2,500 in fines, $613 in court costs, and 101 days credit towards the sentence.
You said 101 days credit?
Correct, Your Honor.
All right, give me just a moment. I need to pull up his motion to revoke.
Mr. Simpson? Yes.
Yes, I hear fine right now.
Ms. Heisel, is the state proceeding on the motion to revoke filed August 17th?
Yes, Your Honor.
Okay. All right, Mr. Simpson, if you will, raise your right hand. I'm going to place you under oath, sir. Mr. Simpson, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. All right, you are David Keith Simpson, is that correct?
Yes, sir.
And Mr. Simpson, you're represented by your attorney, Mr. Merleader. Are you pleased with his representation of you?
Yes, sir. Most definitely, sir.
Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
And it's my understanding that it's your intent to plead true to the counts alleged in the state's motion to revoke in exchange for a recommendation of 3 years TDC with 101 days credit with a balance of the financial obligations that you owe. Is that your understanding of the plea agreement?
Yes, sir.
Yours as well, Mr. Merleader?
Yes, Your Honor.
All right. And Mr. Simpson, you appeared before the court on March 1st of 2016 and pled guilty to the third-degree felony offense of driving while intoxicated, third or more. Court reviewed the evidence, found that there was sufficient evidence to convict you. The court did convict you on that date and assessed your punishment at 10 years confinement in the Texas Department of Criminal Justice. Court also imposed a $2,500 fine. Court then suspended that sentence and placed you on community supervision for a period of 5 days. I'm sorry, for a period of 5 years. And it was during that term of your community supervision that the state has filed their motion to revoke and has alleged in 4 separate counts various ways that you have violated your community supervision. Have you had the opportunity to review that motion to revoke with your attorney?
Yes, sir.
Mr. Merleader, does your client waive the formal reading of the state's motion to revoke?
Yes, Your Honor.
All right, Mr. Simpson, then the court asks you at this time, how do you plead to counts 1, 2, 3, and 4 as contained in that motion? Are those counts true or not true?
They are true, sir.
And are you pleading true because those violations are in fact true for no other reason?
Yes, sir.
Has anyone threatened you, forced you, or otherwise pressured you to plead true to these counts?
No, sir.
All right, the court will accept Mr. Simpson's plea of true to the counts alleged in the state's motion. Mr. Murleader, any objection to the admission of the defendant's waiver of rights and plea of true in evidence?
No, Your Honor.
All right, the court admits the defendant's waiver of rights and evidence, and takes judicial notice of Mr. Simpson's judicial confession. Is there anything further from the state,
No, Your Honor.
from the defense?
Nothing further, Judge.
All right, then based upon the evidence before the court will find that Mr. David Keith Simpson has violated the terms and conditions of his community supervision. The court hereby revokes his community supervision, assesses his punishment in accordance with the plea agreement at 3 years confinement in the Texas Department of Criminal Justice. The court orders him to pay the balance of his financial obligations previously imposed, and the court awards Mr. Simpson 101 days credit towards the sentence in this case for time already served. Mr. Simpson, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you go with the bailiff to be fingerprinted. Good luck to you, sir.
Yes, sir. Thank you, Judge.
You're welcome.
Thank you, Your Honor. That's all the business I have for the court, Judge. May I be excused?
Yes, thank you, Ms. Murleader. Ms. Abraham,
Yes, sir.
is Mr. Tabby up there by chance? Corey Tabby?
No, sir, they're just bringing them one at a time.
Okay.
And you don't see the Ramsey unit?
Do not.
I'll try to go back and call them.
I have Mr. Ashmore waiting, and then I see Mr. Adams there in the back. So just let me know whoever's coming up next.
Okay, yes, sir.
We'll get Mr. Tabby straight up here. That's what the court pleases.
Are you ready, Mr. Adams?
Good luck to you.
Either way, Tabby are done.
I think done is closer.
Okay. Judge Martin? Okay, Mr. Adams is ready.
All right, court call CR 18308, CR 18472, State versus Calvin Leroy Dunn. I believe that we are set today in each case for a status of the court's in-camera review of the CPS records. The court has completed its review of the CPS records produced for the in-camera review. The court has ruled, I've not signed the order yet, Mr. Adams, but the court has ruled that, or will be ruling that there is approximately, actually precisely, 3,129 pages of CPS records that the court believes are essential to the administration of justice. The court is in communication with the Department of Family and Protective Services in regards to how those records are to be produced, whether it's from the copies that have been provided to the court or if it needs to go back through the department for the redaction process. I have a call in to the regional attorney for the department, and as soon as I get that call back and some information, then the court will sign the order and send those records to you, Mr. Adams, for your use in Mr. Dunn's defense. So I think previously I told you there was over 14,000 pages of records. I've reviewed all of those, and 3,129, I believe, should be released to Mr. Dunn. And the order is going to contain appropriate admonishments and warnings regarding the production and release of those records.
Yes, Your Honor. Understood.
So I believe that Mr. Dunn is currently, or was rather, on the court's trial docket as a special setting that was removed due to the COVID orders issued by the Court of Criminal Appeals and Supreme Court. So I think the best action at this point is to set this for just to place on the jury selection docket. And once, I don't believe that we'll be trying Mr. Dunn's case before the end of the year. So that should give you ample time to review the CPS records.
It should, yes, Your Honor.
And obviously, if you don't get that completed and you need additional time, you'll file a motion for continuance. So I think at this time, we'll place Mr. Dunn on the court's running jury trial docket, and we'll set it on November 16th. And so unless you receive notification from the court, Mr. Adams, you will not need to be present on that day. Once the case reaches the court's top 10, then you'll be notified.
Yes, Your Honor. Understood. Thank you.
Any questions about that?
No, Your Honor. No questions.
Okay. All right. Then, Mr. Dunn, we'll have some paperwork brought to you on the 16th with your next date. Okay.
Yes, sir.
All right. Thank you, gentlemen.
Thank you, Your Honor. That's all I have, Your Honor. May I be excused?
Yes, sir. Thank you for being here. Appreciate it.
Thank you, Your Honor.
Okay, I spoke with the Ramsey unit, told them that we were back online, so.
Okay. I'll watch for them.
Okay.
And so if we could have, who's
Mr.
up?
Tabby.
Mr. Tabby, I've got Mr. Ashmore. I'll go ahead and bring him in.
Okay.
All right. Thank you. We're off the record. Mr. Ashmore, they're bringing your client up at this time.
Okay, thank you, Judge.
So as soon as they get Mr. Tabby in there, we'll get going.
Yes, sir. Thank you.
Okay, Judge, we have Mr. Tabby.
Okay, just one moment.
Okay.
All right, Mr. Tabby, if you'll step on up to the podium. All right, Mr. Tabby, can you see your attorney, Mr. Casey Ashmore, on the screen?
Yes, sir.
Mr. Ashmore, can you see and hear your client?
I can, Your Honor.
Okay, good. This is in cause numbers CR 20228 and 229. CR 20228 is arraignment for a third-degree felony tampering or fabricating charge. 229 is an aggravated assault with deadly weapon. We're set for pretrial in that matter. Mr. Ashmore, have you gone over the indictment with your client, Mr. Tabby, for the tampering charge?
He and I have spoken about it. I have informed him the nature of the allegations. I thought we had already done an indictment, but just briefly, Mr. Tabby, you understand that there is a second allegation for tampering in this, that basically we have a companion case, that is a third-degree felony. And I think the judge has just screen shared this with us. Can you see that, sir? Corey, can you
Yeah.
see that?
I'm just reading it.
Okay. Is your name spelled correctly, Corey Thomas Tabby?
Where's it at?
Oh, right there.
Yes, sir.
And you understand that the state alleges that on May 23rd, you interfered with an investigation by getting rid of a knife and bloody clothing.
Yes, I understand.
Okay, and you want to enter a plea of not guilty at this time to that offense, correct?
Yes, sir.
Okay.
All right, the court will enter a plea of not guilty for Mr. Tabby in cause number CR 20228. And Mr. Ashmore, what's your announcement for the pretrial in 229?
Well, Judge, we just got the last of the videos today. There's a lot of data in this matter, and there were 2 videos missing, whether they were stuck on another DVD or not. Anyway, I went by the DA's office this morning and got them. I don't anticipate a contested pretrial, a need for any kind of contested pretrial, nor do I think we'll be filing any pretrial motions at this time, but I would ask the court for leave to consider that if I need to late file something, and then just reset us for a docket call so that the state of Texas and I can continue to work on plea negotiations. I informed them about some facts that I don't think they were aware of this morning. And like I said, there were 2 witness interviews, my client and another eyewitness that I had not, like I said, either I lost them, ate them, or we didn't have them, and I'd like a little time to digest them. But I don't think we're going to need a lot of time to come back, Your Honor.
All right, what the court's going to do is, seeing as Mr. Tabby was just arraigned today on the tampering charge, the court's going to set each case for pretrial on December 8th at 1:30. If Mr. Tabby remains in jail, it would be at 9 a.m. if he is on bail. So, Mr. Tabby, this would be the only notice that you get if you make bail in both of these cases. Then you're ordered to be back before the court on December 8th. That's a Tuesday at 9 a.m.
Okay, yes, sir.
Okay.
Anything further, Mr. Ashmore?
No, thank you, Your Honor. Mr. Tabby, I'll be back in touch with you as soon as I can, sir. It'll be before the end of the week.
All right, you're free to go, Mr. Tabby.
May I be excused, Your Honor?
Yes, thank you, Mr. Ashmore.
Thank you so much, sir.
Just reset, move.
What day do we have?
December 8th.
What time?
9 AM if he's bonded out, 1:30 if he's going back to the.
You'll have to unmute yourself. When you hit that copy machine, it sounds like a freight train coming to the courtroom.
Can you get in court applications and see if there's another number for the Ramsey? I had it in my notes section, but I can't, nobody out here has court applications.
Sure. Someone just zoomed in. Let's see. This may be it. Call in user 1.
Okay, good.
Let's try it and see.
Okay.
This is Judge Martin in Van Zandt County. Do I have a call-in user regarding Michael Lee Doan Jr.? You're currently muted on your telephone.
Can you hear me?
Yes, I can hear you. What's your
Okay.
name?
Michael Lee Doan.
Okay, you're Michael Lee Doan Jr.?
Yes, sir.
All right, Mr. Doan, this is Judge Chris Martin of the 294th District of Van Zandt County. We are currently on the record in the courtroom. Present in the hearing is the Honorable Jonathan Manning, appointed counsel for you, Mr. Doan. Also, we have the attorneys for the state and my court reporter. So, Mr. Manning, I believe that we were set today on the state's motion to disqualify attorney. And state, are you there? Are you available?
We are, Your Honor.
Can y'all move to where we can see you on? I can't really hear you over there. Okay. All right. So, Mr. Doan, you will not speak unless I call on you. So at this time, I just want you to listen.
Okay, yes, sir.
All right. All right, Mr. Cox, I believe it was your motion to disqualify Mr. Manning as counsel for Mr. Doan. Is that correct?
Yes, Your Honor.
All right, go ahead.
Judge, we would just re-urge the written motion that we filed with the court a few months ago. I believe there are 3 grounds that were raised in that written motion, and we would just re-urge those written grounds.
Mr. Manning, do you want to respond?
I'll reserve my opening at this time, Judge.
Say that again.
I'll reserve my opening at this time, so you can put on any evidence or just re-urge.
Is there anything else from the state, Mr. Cox?
Your Honor, we just re-urge our motion.
Okay.
Judge, if I may.
And we'd ask that the court take judicial notice of the attachments that were filed along with the written motion.
Any objection?
No objection to the substantive nature of those. I would request that on Exhibit D that we strike or seal the personal information that's contained therein.
But no objection to the court taking judicial notice of it?
No.
All right, the court will take judicial notice of the file with regards to the state's motion to disqualify attorney. Go ahead, Mr. Manning.
Thank you, Judge. Judge, I believe that the state and I obviously disagree on this matter. The burden is on the state. I don't believe the state has been able to prove that there was a personal and substantive involvement for the motion to revoke for Mr. Doan. And I plan on calling testimony to support the arbitrary and targeted application of this Rule 110 in this case.
And you're going to call a witness?
Yes, Judge.
All right, who would you call?
I'd like to call Richard Schmidt.
All right, Mr. Schmidt, if you'll come to the table up here with the microphone. And Mr. Schmidt, I'm going to have you raise your right hand and place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Go ahead, Mr. Rainey.
Thank you, Judge. Mr. Schmidt, are you an attorney?
Yes, sir.
Okay. And how long have you been an attorney?
About 16 years.
Have you been an attorney for the Van Zant District Attorney's Office?
I have.
Okay, and how long were you an attorney for the Van Zant District Attorney's Office?
On 2 different occasions, approximately 8 years.
Can you hear Mr. Fox?
I could barely hear Mr. Schmidt.
How about now?
That's better.
Approximately 8 years.
And during the time that you weren't at the DA's office, where were you employed?
I was in private practice.
Who is one of your former clients that you represented both as a defense attorney and as an attorney for the state of Texas?
I'm going to object to the relevance, Your Honor.
Want to respond?
Your Honor, I think it's highly relevant. They're seeking to apply a rule under 110 that has never been applied, as is going to be shown by this witness's testimony.
Respond to that, Mr. Fox.
Your Honor, I fail to see how any prior application of this rule is relevant in this case at hand. Just because it may or may not have been applied in the past still does not mean it's not a valid motion to disqualify.
Okay, court's going to overrule the objection at this time. Go ahead, Mr. Rainey.
I'll re-ask the question, Mr. Schmidt. Who is one of your former clients that you represented on both sides?
Well, there's been quite a few, but most notably and most recent is Adam Jared Bradley.
And Judge, at this time, I'd ask the court to take judicial notice of Adam Jared Bradley's file. That's CR 15-00211 here in the 294th District Court.
Any objection from the state?
No, Your Honor.
All right, court will take judicial notice of the file CR 15-211 State versus Adam Bradley.
Mr. Schmidt, when you started working on Mr. Bradley's case, who were you employed with?
Van Zant County District Attorney's Office.
And when was that that time period that you began work on that case?
I note that the judgment of deferred entered on Adam Bradley has my name on it, was entered June 23rd, 2015.
Okay. And did you do subsequent work on Mr. Bradley's case in April of 2016?
I show that I signed the state's motion to adjudicate and revoke community supervision on Adam Bradley's case. It was filed for record on that date.
Okay. And did you subsequently leave the DA's office after 2016?
I did.
Okay. And bring your attention to a document from April of 2019. Were you appointed on Mr. Bradley's case to represent him on a motion to revoke?
I was.
And did you subsequently resolve Mr. Bradley's case with the DA's office in 2019?
We resolved it by plea, yes.
Were there any other cases in which you represented indigent defendants that you had previously worked with the case while at the DA's office?
I do know in the last 15 years or so, I've worked under 3 different district attorneys and been in private practice twice. And there have been quite a few. Recently, within the last 2 years, I can recall Kawania Banks. I don't recall the cause number. She was one, and I believe there might have been some issue with a Rebecca Lowry at one point in time.
And did you ever believe that there was a conflict when you represented those individuals who you had been both the attorney for the state and their attorney?
The only potential conflict that I believe professionally was of interest was the conflict to my client. As one attorney, I made them aware that at one point I'd either prosecuted them through the DA's office or worked on their case through the DA's office, and let them know that they had the option to object to my appointment.
And was there ever a formal objection filed by your clients or by the DA's office under those three administrations that prevented you from working on those cases?
No.
Can you briefly explain the process based on your understanding of when you worked at the DA's office as to how a motion to revoke was signed and the information that would be reviewed for a motion to revoke?
In general, the process was short. A representative from the Van Zandt County Community Corrections Department, the Probation Department, would bring their motions over. They were prepared. We reviewed them and made sure they matched, and then signed off on it.
And beyond what was contained in the motion to revoke, as well as the violation report, was there a personal substantial involvement when signing the motion to revoke that was provided by the Van Zandt Community Supervision Department?
No, the violations were held in the probation department's file, so we would not have been personally aware of each and every violation.
And further, when being provided with that information, as the state's attorney, was that information turned over as required by law to the defense attorney who represented the individual that was being violated?
Yes.
Your Honor, at this time I pass the witness.
Mr. Cox, any questions for Mr. Schmidt?
Yes, Your Honor. Good afternoon, Mr. Schmidt. How are you?
Good afternoon, Mr. Johnson.
Mr. Schmidt, who represented Mr. Bradley when you were prosecuting him with the DA's office? Who was his attorney?
That would have been John Scott.
Okay. And you signed the motion to revoke for Mr. Bradley and then represented him in private practice. Is that correct?
I signed the original motion to adjudicate, yes.
Okay. Was your name on his judgment, the original judgment that placed him on community supervision?
Yes.
Okay. Were you involved in the plea negotiations with Mr. Scott that resulted in Mr. Bradley being placed on community supervision?
Yes.
Okay. So you were involved in the plea negotiations. Your name was on the judgment, and then you signed the motion to revoke. Is that all correct?
Yes.
Okay. And did you recommend a bond as well for Mr. Bradley when you signed the motion to revoke?
Most likely. I think there was an amended motion to adjudicate that was filed later.
Okay. Now, Mr. Schmidt, would you admit that under the rules of professional responsibility, all of those actions would create a conflict?
No, I would not.
Why would you not agree to that?
The conflict is held in the hands of the defendant, and the defendant was made aware of my prior position with the DA's office. He did not object.
Okay. And so you don't believe that the state has a right to raise a conflict between the defense attorney and the defendant?
Under the circumstances that exist, no. There is no confidential information that the state has that a defense attorney does not have. And that was true in this county pre-Michael Morton and post-Michael Morton. The only time I think there would be a conflict is if the case was set for trial and there was particular trial strategy or some sort of work product that the prosecutor had in their possession. At that point, I believe there would be a conflict.
Okay. As a prosecutor, would you sometimes discuss with the probation officer the details regarding the allegations in the motion that you're...
At the time of signing or at the time of prosecution?
Hang on, Mr. Cox, can you unmute again? I'm having some technical issues over here. Just unmute. All right, and I'm gonna attempt to mute Mr. Doan. I'm gonna mute you. We're hearing a lot of the jail noise in the background, so.
Okay, yes, sir.
I'm going to mute you, and there may be a time I'm going to ask you to unmute yourself if you're called to testify, okay?
Yes, sir.
But when I mute you, you should still be able to hear, okay?
Okay.
Mr. Schmidt, do you have a copy of Rule 110A of the Rules of Professional Conduct available to you?
Not in front of me now.
Okay. I'm going to read it to you. This is subsection A. Except as law may otherwise expressly permit, a lawyer shall not represent a private client in connection with the matter in which the lawyer participated personally and substantially as a public officer or employee unless the appropriate government agency consists after consultation. Did you get all that?
I believe so.
Okay. And in this case, the Van Zandt County Criminal District Attorney's Office would be the proper government agency. Do you agree with that?
Yes.
Okay. And would you agree that participating in plea negotiations with the original defense attorney would be personal and substantial involvement in a criminal case?
No.
You don't?
Not under these circumstances, no.
Okay. Do you believe that reviewing and signing the motion to revoke and reviewing the allegations as alleged would constitute personal and substantial participation by a public officer?
Under practice, no.
Okay. Nor do you, I guess, then believe that requesting a bond or no bond in this case would be personal and substantial participation?
Well, it was not no bond in this case, and the request for the bond is discretionary and the judge signs that. So the answer is no.
Okay, but the state does often make a recommendation to the court on what the state believes a bond should be, correct?
We do.
Okay, and would you believe that would be personal and substantial involvement in a criminal case?
Under the circumstances here, no.
Okay, what would be personal and substantial under these circumstances involvement by a public officer?
Could you clarify the question?
Well, I mean, if you don't believe that participating in plea negotiations is substantial involvement with the case, what is?
Well, I said under these circumstances, it's not. I engaged in plea negotiations post judgment. My representation as a private attorney was post judgment. So the difference is significant. Okay,
well, let's discuss this case in particular, Mr. Schmidt. Are you aware of who Mr. Doan's original attorney was?
No.
Okay. It was Steve Green, and if Mr. Manning personally negotiated the terms of the plea to which Mr. Doan pled guilty, do you believe that would be personal and substantial involvement in a criminal action?
No.
So your testimony is that negotiating the plea, negotiating the terms that can, I'm sorry. Your testimony, Mr. Schmidt, is that participating in plea negotiations and making the offer to which the defendant then accepts and pleads guilty is not personal and substantial participation in a criminal case.
In practice, it's personal, but it's not substantial.
You don't think that negotiating the terms of a plea is substantial?
As a matter of course, no.
What do you mean as a matter of course?
As a matter of course, it is a review of the file, and most of it is a matter of pressing a case. I don't think that the
I'm sorry, I couldn't hear you, Mr. Schmidt. You were breaking up there.
The answer is no, because it's almost a matter of, I'm looking for the right word. You don't get substantially involved in the case. You look at the indictment and you look at the criminal history and you make an offer. That you do that 500 times in a year, you wouldn't remember one or the other. So no, it's not substantial.
Okay. And Mr. Schmidt, what percentage, in your opinion, of criminal cases result in a plea bargain?
Almost all of them.
Okay. So then if almost all of our cases are resolved with a plea bargain, then what is substantial involvement in a criminal case from a prosecutor's perspective?
I would say in practice, substantial involvement is trial preparation.
Okay. And Mr. Schmidt, what's the arrangement between yourself and Mr. Manning in your law office? Is he a partner? Is he an associate?
I'm not going to answer that question. It's not relevant.
Well, I think it is, Mr. Schmidt, because under the rules, we could disqualify your entire firm on any case Mr. Manning had a substantial involvement in, yet we've chosen not to do that.
Well, and I would say that you've chosen not to do that with any of my cases. So that's the point. That's why we're here today.
Okay.
This one it seems to be a little bit unusual.
And when was the last time you were employed at the district attorney's office?
Oh, I think I left in 2016.
Okay. When did Mr. Manning leave?
I don't recall. I believe it's about a year ago.
Okay. Would you agree with me that the vast majority of the cases that you participated in as an assistant DA have since been resolved?
I would hope so.
Okay. So therefore, there would be much fewer cases, or many fewer cases in our office which still have your fingerprints as an assistant DA. Would you agree with that?
I don't necessarily agree with that, but I don't know. It could be true.
Okay. I'll pass the witness.
Just briefly, Judge. Mr. Schmidt, you brought out a distinction that you believe that the connection in a particular matter may have to do with where it is, either pre-judgment or post-judgment. Was I correct in understanding that there's a distinction in your mind that a matter pre-judgment, i.e. a plea to an underlying offense, and a matter post-judgment, i.e. resolution of violations of probation, are distinct in your mind?
I don't know that as a general rule that there's a distinction. In this particular case, Adam Bradley, there is a distinction because that is when I took over post-judgment.
No further questions, Judge.
Mr. Cox, any further questions to Mr. Schmidt?
No, Your Honor.
All right, Mr. Schmidt, you're executed. Free to go. Any additional testimony or witnesses, Mr. Manning?
No, Judge.
Mr. Cox, any rebuttal?
No, Your Honor.
Argument?
Judge, I have to respectfully agree with Mr. Schmidt. I believe that personally negotiating the plea bargain, which the defendant then agrees to and pleads guilty to, is personal and substantial involvement in a criminal case. And I'll agree with Mr. Schmidt, and I guess with Mr. Manning as well. Just having your name on a judgment doesn't necessarily per se mean that you had personal and substantial involvement in a case. Just signing a motion to revoke and recommending a bond doesn't necessarily per se mean that a prosecutor was personally and substantially involved in a case. However, Judge, where I believe this case differs, as opposed to all of the other cases where Mr. Manning's name has appeared on a judgment or his name has appeared on a motion to revoke, is that Mr. Manning personally negotiated the plea deal to which his client that he currently represents, Mr. Doan, pled guilty to and agreed to. And I understand, I get the argument Mr. Manning is making, Judge, but if we wanted to, for lack of a better term, pick on him, we could have filed motions to recuse or disqualify on every case where his name is on the judgment or every case where he signed the motion to revoke, and we haven't done that. The reason, Judge, this case is different is because Mr. Manning negotiated the plea bargain as an attorney for the state. We believe that is personal and substantial involvement. Again, Judge, I see where Mr. Manning's going, that this is somehow personal. It's not. If it were personal, we would have filed dozens of these motions. If it were personal, we would have tried to have Mr. Schmidt disqualified in a number of these cases as well, because the rules of professional conduct would prohibit him from representing clients that Mr. Manning represented when he was at the district attorney's office. We haven't done that either, Judge, because this case is different. And Judge, I believe the rules are pretty clear. Except as law may otherwise expressly permit, a lawyer shall not represent a private client in connection with the matter in which the lawyer participated personally and substantially as a public officer or employee unless the appropriate government agency consents after consultation. And again, Judge, proper government agencies, a district attorney's office, we have raised a valid claim of a conflict. And Your Honor, we are asking that the court, well, one other thing I'd like to point out, Judge, in the motion or the response that Mr. Manning filed with the court, he even admits himself in subsection 3 that under 110A, a potential conflict exists based on the information provided in our motion. So Judge, if there isn't a conflict here, I don't know where there's a conflict, and we'd ask that the court grant the state's motion.
Thank you, Mr. Cox. Mr. Manning, you want to respond?
Just briefly, Judge. I don't know whether it's about personal or not, but it's about what the law says. And the law says that there must be a connection with a matter that is personal and substantial. And so, Judge, we've had testimony today that it's been the practice here in Van Zandt County that these cases that are resolved, that go to a plea, have been handled by people who have been in the office, have left the office, and represented individuals on the other side. And so, Judge, the personal and substantial nature, I think, goes just a little bit deeper than the signatory on the judgment, signatory on the motions. It requires something further, something more substantial than just getting the case moved through the docket. And furthermore, Judge, these laws, these rules are created for confidential information, confidential privileged information that's held by the state, and not at any point in time during the filing of this motion nor this hearing has there been evidence there was confidential or privileged information that was obtained in my employment that would be used to prejudice the state going forward. And so for those reasons, that because the state hasn't met their burden to prove that the matter is personally substantially involved, that I was involved in that, I'd ask that the motion be denied. And I'd further ask, as I said before, that the information contained in Exhibit D, the personal information, be struck or sealed.
Thank you, Mr. Manning.
Judge, if I could just point out briefly that the practice here in Van Zandt County does not supersede the rules of professional responsibility. Those trump whatever practice may be here in Van Zandt County.
Are either of you concerned at all with what Mr. Doan's position is?
Your Honor, I've already I've written my client and we discussed this issue with him, and at this time, he has not made me aware of any objection to my representation of him, even though I've disclosed this information to him.
So, but there's nothing before the court that tells me that if there is a potential conflict that can be waived, that it's hereby waived by Mr. Doan. I've got nothing in taking judicial notice of the motions, the response, the file. I've seen nothing from Mr. Doan. And Mr. Doan's involved in this hearing, but he hasn't been called as a witness. So,
Judge, if Mr. Doan was wanting to set forth his objections, you would see a motion that would be filed asking me to have substitute counsel.
Judge, I'd again point out, though, that the language of Rule 110A, unless the appropriate government agency consents after consultation, I believe it's the state's conflict to raise. It's not Mr. Doan's.
What is the state's concern with Mr. Manning? That he does have confidential information that could be used to oppose the state in a motion to revoke hearing on violations of community supervision?
Potentially, Your Honor. He would have facts of the underlying case as the attorney that represented the state, that participated in the plea bargain negotiations. I can't say what he does or doesn't know. Again, I just feel that the rules are pretty clear cut here, that again, we could have filed dozens of these motions, but there comes a point to where we have to say, okay, enough is enough. He can't represent this guy. He was too involved in this case to now represent him as his defense attorney.
May I respond, Judge? While I may or may not have been, according to Mr. Cox, personally substantially involved in the initial investigation of Mr. Doan, it has no bearing on this matter before the court right now. The matter before the court we're on right now is a motion to revoke that is dealing with the violations that occurred afterwards. And there's no evidence that I have personal substantial knowledge of things that would be privileged or confidential that would disallow me from being able to serve as Mr. Doan's counsel without prejudicing the state.
Just so for my clarification, it appears that Mr. Doan was convicted of the third-degree felony offense of tampering or fabricating physical evidence. Punishment was assessed at the maximum 10 years confinement, suspended, and placed on the maximum period of community supervision for 10 years with a $1,500 fine. Is that correct? That's correct. And the violations alleged: count 1, commission of a new offense, possession of controlled substance. Do you represent Mr. Doan on that charge, Mr. Reed?
Judge, I have not been given any information about the violations. I don't have any idea of what the violations are, or what's being alleged against him at this time.
So you don't represent him in Paris, Texas?
No, Judge.
Count 2 is that he committed another offense of possession of marijuana in Paris.
Don't represent him in that either.
That he didn't pay his court costs, fine, or attorney fees. Count 4 that he didn't pay his supervision fees. Count 5 that he didn't pay his restitution for 3 months, and that he didn't do his community service restitution. All right, do either one of y'all have any cases for the court?
I do not, Judge.
Mr. Cox?
No, Your Honor.
Okay, all right, then the court will take this under advisement and will do some legal research of its own and issue a ruling in this case. Anything further, Mr. Cox?
No, Judge.
Anything further, Mr. Manning?
When will we be resetting Mr. Doan?
Let's set Mr. Doan for a status, we'll call it status of counsel, and let's set him on, are you available? When did I set you previously today, Mr. Manning?
November 3rd and December 8th.
Let's set Mr. Doan then for Tuesday, November 3rd. And Mr. Doan, I can't unmute you on my side. Can you unmute yourself by chance?
Hello?
Yes, okay. So Mr. Doan, were you, did you hear the entire hearing?
Yes, Your Honor.
Okay. All right. So Mr. Doan, what we're going to do is I'm going to set your case for a status on whether or not Mr. Manning is going to remain your attorney. And I'm going to set that and hear it again on Tuesday, November 3rd. So my coordinator will most likely be in contact with your TDC unit if you're still there.
Okay.
And if you're unavailable, then I may waive your appearance for that hearing. And
okay.
I'm sure Mr. Manning will be in contact. Do you have any questions at all, Mr. Doan?
No, Your Honor.
Okay. All right. Well, Mr. Doan, I appreciate your patience. Sorry for the delay in having our hearing today, but we will be in contact with you soon. Okay. And tell the staff there that the court appreciates their cooperation in making you available today.
Okay, I will. Thank you.
Thank you, sir. All right. We'll be adjourned.
Thank you, Judge. May be dismissed.
You may.
May the state be excused, Your Honor?
Yes, we don't have anything else. Does the jail have anything, Mr. Cox, that you're aware of? Any extraditions or anything? Capable for comments? No? Okay. All right, then we'll be concluded.
Thank you.
Thank you, Mr. Abraham.
You're welcome.